You signed this IOU, you drove the car away, correct? How long did the car work for?
A day.
It broke down?
Yes, sir.
Right. Have you taken it to another mechanic or an independent person?
No, I brought a new car.
Very sensible. But did you take that car to an independent person?
I have not.
To assess whether or not these parts were bought, to assess whether the work was done to a standard?
I have not, because it's still in my garage and I didn't think about it.
Well, it's worth something for scrap, right?
Yeah, of course.
Now, just to be clear, you signed this IOU, you say, because you were under duress of some kind.
It's true, sir.
What was the nature of the duress? You wanted your car?
I wanted my car back.
Right. That's not duress. Do you understand?
I couldn't bring my son to school. I couldn't go to work in the morning if I didn't have my car. I couldn't get back home. So I needed to sign it. I didn't have £150 in my pocket. He wouldn't give me the key back. That's why I signed it.
Anything you'd like to add, Vishnu?
Yes, just concerning that invoice that he sent to me, I detailed it and gave him a copy of this letter, so you would know that...
when was this letter prepared?
As soon as I receive that copy.
Right, 29th of March. Did you get this letter?
Oh, I did receive a letter from him,
Let's
yes,
have a quick look, very quickly. This is the letter you prepared?
Yes, I did.
Let me read an interesting part of it. I had 4 treatments at £25, total of £100. This then drops a balance of what you owe to 170. However, all the money I'm asking for is £130. In other words, you have explicitly acknowledged here in this letter that the treatments that were given to you, albeit at a discount, I suspect because his boss said you can have a discount, had a value. Normally they're £30, 4 treatments at £25.
No, what I meant...
Why have you written that?
Because I said to him, if you're saying that you owe me nothing, I'm explaining to you that if you wanted me to pay out of the money, if I were going to charge you for my call-out charge, my labour fees, it would have been that, and if you had charged me for your full massage, then it would have been £100, so it would have been...
When you need to explain something in a paragraph, it means it's rubbish.
I do apologise, sir.
Now, because you've written that in this letter, that leaves me with the impression that you understood at some point you had to pay. In other words, there was a value. It wasn't free of charge. Now, I look at the letter as a whole, and it may be that you're simply saying, if you were hypothetically charged for massages, that would be the value.
Yes.
That's sort of what you say. Have you had a chance to read this? What do you say in reply to that?
I did read it, but I did not understand it. That's the problem.
Well, that makes 2 of us. Vishnu, Rimu. Rimu has signed an IOU, explicitly making clear that he owes you that money. His argument that he did so under duress, in other words, he was threatened or felt under significant pressure, is rubbish. It's quite clear to me that there is a legal obligation for him to pay that money, and so this court awards you £130. I don't think Vishnu is a liar. Do you understand? The award of this court is to you, Vishnu, for £130. For more Judge Rinder cases, click here. And if you've got a legal issue yourself, get in touch with us by clicking over here.